SJC-10826, Commonwealth v. Shatera M. Thomas.
Good morning.
Good morning, Your Honors.
Hold on, please.
I'm sorry.
We want to get you on tape here, and Mr. Keneally has to push the button for us.
Thank you, Judge.
All right, let's proceed. Yes.
Thank you very much. Good morning, Your Honors. If I could start just with two housekeeping matters. First, my name is William Smith. It's my privilege to represent Ms. Thomas in this matter. May it please the Court. In terms of housekeeping, my sister was kind enough to call me the other day. Obviously, the tapes, the interviews of the videos of the interrogations, I had addressed that with the trial court some time ago when I was down there in Brockton for a civil case. They told me it was their understanding that that was going to be sent. I don't know whether it was, but my sister and I would ask that take place. If there's anything I can do to expedite that, I'm happy to do that. And secondly, if I could, respectfully, if I could reserve 2 minutes of my time. Your Honors, I would suggest this case is about the phrase lawyered up in two regards. I'd like to speak about the first one vis-a-vis what happened at trial. The Commonwealth essentially is saying that because the defense counsel had asked that the videos be admitted, there was some discussion outside the presence of the jury with the judge, and of course, basically defense counsel said, well, of course, the motion to suppress having been denied, rather, then it is what it is, and he asked that it be introduced in its totality, that is to say, the videos. The problem with that is that the Commonwealth is saying that therefore this evidence of the invocation of the right to, my client's invocation of the right to counsel, therefore properly came in and was used to her benefit. And I would suggest this is a case where there was a plethora of evidence to establish, to question, to challenge the voluntariness of those statements without having the jury have to hear that my client had invoked her right to counsel.
Well, what do you say that should have happened with the video once the defense counsel said it all should come in?
Well, I would suggest it was ineffective assistance to not ask simply that be redacted. As I was saying, I mean, there was ample evidence here upon which the defense theory that these statements were coerced or were involuntary could have come in without.
Just on that point, though, I understand what you're saying about the lawyered up, but in fact, the actual interchange with the detective in which he used that phrase lawyered up is one of the key pieces of the, I take it, one of the key pieces of the lack of voluntariness that you are alleging.
I would.
And he was, at least as it, I haven't listened to the transcript, but in terms of reading the words, it was at that point that he sort of sounds annoyed. Well, I'm not going to talk to you. He's walking out of the room. I mean, that's a pretty key place, isn't it?
If there was nothing else, and as in fact, one the case that there was another case that the Commonwealth had cited, or it's actually the principal case, and I'm sure I'm mispronouncing it, by Pai-Tu Hang from this court, 2011. Totally different circumstances, Your Honor. The salient thing there was sort of that was all they had. That's just not the case here. As you'll see in the video, Your Honor, when Your Honors watch the video, I mean, there was throughout the entire videos, the defendant is clearly in a rough state. Now, obviously, that's a separate issue with respect to the admissibility of the statements, but with respect to the voluntariness, the live issue at trial, there was her demeanor. There was the fact that also there was a friend who was with her who said that my client had been on a crack cocaine bender for days, you know, at the time in proximity to these statements. So for the jury to hear that my clients had invoked her right to counsel, Your Honor, I would suggest as the case law Doyle and Pexdeo and all of those cases clearly recognize, that is just horrendously devastatingly prejudicial for the jury to hear. So they simply, very easily, very nip and tuck, for lack of a better term, could have and should have been requested to have been excised, to have been, so that the jury would not have heard it. I read this over and over. I looked, in fact, just last night again for something, some indication that the judge had perhaps put some sort of curative measure, effectuated some sort of curative measure. That just is not the case.
Did you ask for a new trial?
Well, I would suggest, in terms of the record, exogenous to the record, is that what your question is, Your Honor?
Well, this whole business of whether or not counsel was ineffective.
Right. I would suggest, Your Honor, even assuming that it is if we look at that as a tactical endeavor, that it's ample from the record that that was unreasonable, an unreasonable tactic. There's ample indication from the record that that was unreasonable. Again, if that was all counsel had, to attack the question of whether or not those statements were voluntary, totally different story. I would have to concede. I would absolutely be constrained to concede that. But that's just not the case here. So here we have more of a situation like McCrae and the other cases that say that where that tactic, it's not just enough that it is a trial tactic, of course, but where that tactic is manifestly unreasonable, and that can be determined, ascertained from the record itself, then that's the situation we have here.
If I could turn your attention to a matter that you did not raise. She was found guilty of deliberate premeditation, I gather, correct? A first degree by deliberate premeditation?
With transferred intent, Your Honor.
Right. What is the evidence of intent to kill?
Well, there were statements that she had made allegedly to the effect, I'm going to burn, and I believe an expletive, the house down.
But that doesn't mean necessarily that she intended to kill Ms. Johnson. It just means she intended to burn down the house.
Correct. Well, it was in the context of directing it toward her. There were a few different statements, and I would suggest, just as a factual matter, every bit of the Commonwealth's evidence here, it became the main witnesses, civilian witnesses for the Commonwealth. It was such a symphony, if you will, of drug addiction and drug use and on the first floor. But those statements were certainly there, and that was...
There was one statement where she said, I'll kill everybody.
Correct. So, I think it's there. I would suggest in terms of this court making a determination whether or not the evidence was overwhelming, however, having said that, I would absolutely not concede that. Every piece of evidence here that was presented by the Commonwealth through their own witnesses had serious problems. Even the precipient witness, who would be ostensibly an independent witness across the street, she said she could only identify her maybe about 80%, that is to say, identify my client. There was indication that she had seen the fire actually start completely on the other side of the home. And especially in the context of here, where there was also evidence clearly that the people on the first floor, in that first floor apartment, were engaged in resining. And the Commonwealth's fire expert witnesses testified, at least one of them testified, that is obviously manifestly can create the danger of fire. There was evidence that the window in which she had allegedly reached in had in fact been boarded up. There was evidence
But
that
well, I know you challenged the voluntariness of her statement, but she did talk about this. There was evidence from her on this very subject, right?
Correct. Which, of course, by that juncture, by the third...
Was the third interview.
Correct, Your Honor. Yes, Your Honor. And by that third interview, that is, of course, when the real damage happened. And so, again, in the trial context, this whole lawyered up issue, again, as I said, there was evidence she had been awake for days on a cocaine or crack cocaine bender. Her emotional state, again, I would suggest is readily visible and apparent from these videos, Your Honors, when you see them. She had been repeatedly interrogated by these detectives. And there was also evidence, too, that even if it was only 2 to 3 detectives who were actually involved in the questioning, there were multiple officers present. So again, we have a mosaic here where the idea that her invocation of the right to counsel, albeit, yes, Your Honor, as Justice Bosford, as you had said, it was a piece of evidence that could be used to establish, well, she was badgered. They were using this term lawyered up, which I would suggest is a very, very derogatory term. It's designed to sort of, well, I don't want to impute, I don't know what was in the officer's mind, but just speaking in the abstract, I mean, it's designed to make the person feel guilty for invoking their right to a lawyer. And so here in this case, both in this regard and vis-a-vis the Miranda issue, it isn't just the invocation, it's this whole use of the phrase, repeated use of the phrase lawyered up. It's not just the repeated use of the phrase lawyered up in the videos, it's the repeated use of it at trial. It's also, respectfully, it was used by the Commonwealth, it was used by the assistant district attorney. And I'm not impugning her motives, but she repeated that phrase and asked, okay, so when did he lawyer up, et cetera, during, when she was getting the chronology of what happened here out.
So your claim here is that the judge, when the defense counsel said, I want to play the entire tape, should have said, no, I will not let you do that. I'm going to require you to redact the portions that include lawyer up?
And thank you for that question, Your Honor. In fact, the case that the Commonwealth cites, Commonwealth versus Peyton-Heng, again, I'm sure I'm mispronouncing it, from this court from 2011, that is precisely what the judge did. And in that case, the use of the invocation was the linchpin of the defense. But before that happened, the judge actually said directly, not just to defense counsel, but to the defendant, essentially, this is bad. This is not supposed to be heard by the jury. This is not admissible in the normal course. I mean, I'm paraphrasing, but that's what the decision says. This is not supposed to be used in the normal course of evidentiary practice, et cetera. And so the trial judge specifically told the defendant that he would therefore, or she would therefore, exclude the invocation if that's what the defendant wished. So the trial judge did precisely that in that case, Your Honor. And then, of course, the salient thing there was, well, it was a totally different story. The defense wanted that because, in fact, that was their theory, was that the defendant did nothing but cooperate with the police. That simply is not the case here. It is manifestly different. And then this court, in that Pai-2 decision, specifically noted that where it is a reasonable strategy, then that's okay. So that's what happened. Excuse me, Your Honor. And so the court said that that was okay. It was a reasonable strategy. And in fact, you had that additional safeguard where that is precisely what the judge did. That just is not the case here. I had also looked, again, I looked for if there was any indication that there was a curative instruction, and that simply is not the case. In Pai-2 as well, the judge gave that instruction twice. Judge gave the instruction at trial while this was coming out, the invocation was coming out, and then the judge gave an instruction in the closing arguments, Your Honor. So it's a quantitatively and qualitatively different situation.
If I can turn your attention to something else, was there any use of accelerants in this case? Was there any indication that any accelerants were used?
No, I mean, the only indication I would suggest with respect to accelerants would be that it was tied to the people in the first floor, not my client. There was conflicting evidence on that. There was indication that perhaps the curtains, or there had been some sort of flammable item near the window.
It was the curtains, isn't that what?
Correct. But again, there was also indication that, in fact, that window had been boarded up. So I would suggest this is far, far from a case of overwhelming evidence. There was also indication as well from one of the Commonwealth's witnesses, I think he was an electrician essentially, and he said that there was faulty wiring, in fact, and it was consistent with certainly was at least consistent with the fire, that may have contributed to the cause of the fire. I mean, but certainly the resonating that was going on the first floor, when you combine that with the fact that there was testimony that the point of origin, at least visibly, was on the opposite side of the home. So it just is not, nothing here in terms of the Commonwealth's case, the loose ends just never tied up, I would suggest. And in that regard, it is a very, very haunting sort of case. Additionally, my client there was a witness who had said that my client was in fact with him. So, I mean, she may have been in proximity. There was certainly evidence that she was in proximity to the scene, but she had been in proximity to the home countless times. She had lived there. She and Miss Johnson were friends. Obviously, they had a serious falling out, but it was one of those situations where it was constantly back and forth, arguing between them. Again, and the Commonwealth noted that essentially their position is that, well, this was asked for by the defense counsel, by trial counsel. This issue with the invocation of the right to counsel was never addressed. That's another thing I stand corrected if I'm wrong on that, but I looked through the volumes of transcripts in the last few days, and I saw nothing to indicate whatsoever that the actual issue of the invocation was ever raised. And so here we have a situation where there was ample evidence that these statements could have, upon which these statements could have been attacked. And thrown into the mix is the repeated references to my client's invocation of the right to a lawyer. And not just her invocation, but this whole business of the term lawyered up. And I cited in my brief, I could not find a case in Massachusetts that addressed where that phrase was used. But I did cite two cases where it was used in other states, and I think that those courts recognized in those decisions, expressly, at least implicitly, if not expressly, recognized the absolute palpable danger in a phrase like that. And I think it just innately carries with it the danger of the jury thinking, boy, that's just a really dirty thing to ask for a lawyer. That just reeks of guilt. And it places, so it's not just the fact that the jury hears about the invocation, it's the fact that the invocation comes tied to this whole phrase lawyered up, which was just absolutely devastating in this case.
So I'm not sure I understand what you said. You looked through the transcript and you don't think the trial counsel ever raised this point in any way? I don't really understand what you mean. In addition to asking for the whole videotape to be played, the lawyer was not sensitive to the fact that there was any problem with the phrase? Is that what you mean?
Correct, Your Honor. That is, I looked to try to see if maybe there was at some point, if that had been addressed specifically, and I found nothing. I mean, obviously I'm going by the black and white by the phrases, but I think it was just, the context was, well, the motion to suppress had been denied, so it sort of is what it is.
Mr. Smith, we'll have to leave it there. You'll be back again.
Okay,
All
thank
right,
you.
Yes.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. If I could quickly turn my attention to the questions asked by Justice Gantz, because obviously they're not addressed in my briefs. Your question on what was the evidence of intent to kill, aside from the fact of lighting a fire at 5:30 in the morning in a three-family house. The defendant hated Michelle Johnson. You hear about that through the defendant's friend, Veronica Copeland. And then Michelle Johnson testified, and this is a transcript, February 16th, page 93. She said that the defendant threatened to kill her, Johnson, while they were talking on the phone. This is the night before the fire. There's many phone calls going back and forth, as substantiated not just by Johnson's testimony, but by the phone records and Veronica Copeland. So there's a lot of phone calls coming back and forth between Michelle Johnson and the defendant. And Michelle Johnson testified that the defendant threatened to kill Johnson, and then on page 134 of that same transcript, that's where she says, I'm going to kill everybody. So I would suggest there was substantial evidence that she was planning to set the fire in advance. She had told Michelle Johnson, "I'm going to burn your house down." The woman across the street heard, this is Andrea Pierre-Louise, had heard the defendant say, "I'm going to torch the place." Noreen Sims, who's known as Buttons, she heard the defendant say, "I'm going to get you all out of that house. There's nothing you can do about it. There's the trespass, the arrest. She keeps
Yeah.
coming back," et cetera. And so I would suggest the evidence is ample that she was intending to kill Johnson and anybody else who was there who happened to get in the way.
But also in the house was the person who was her boyfriend.
Banger, yes.
Banger.
Yes, who had repeatedly told her they were done, there were fights in the street. Andrea Pierre-Louise testified about the fight in the street, and she said this woman wasn't understanding that he didn't want to be with her anymore. And so Banger was also in the house, but there had been the whole taunting thing about Buttons. Johnson had told the defendant that Banger and Buttons were together, implying that they were having a sexual relationship, which was false. And the defendant, went bananas, for lack of a better word. And then Buttons called her back, because Buttons had a self-interest in that. She didn't want any of the anger coming down on her, but she said she convinced the defendant that there was nothing going on between them because Buttons was actually involved with a different person. So, but it was that kind of taunting, angry, and ongoing back and forth between Michelle Johnson and the defendant. As to your, I'm sorry, did you have a question?
No, you're on a roll, so go ahead.
As to your question about accelerants, I don't have the page numbers, but the Commonwealth's 3 fire experts that testified all said there was no accelerant accelerant use. They weren't testing for alcohol, they were testing for gasoline, those kinds of things. And the testing they did was they brought in that dog. I believe his name was Milo. It wasn't their regular dog, but they got a dog, they brought him in, he sniffed around and did not alert for accelerants. So they had no reason to believe there were accelerants.
Wasn't the, putting the challenge aside, but her statement was that she put a match in.
She said she used a lighter
A
and
lighter.
lit the curtain
Lighter, okay.
in her statement, yes.
So there's nothing, the evidence
evidence
is not inconsistent with that at all?
Evidence is not inconsistent. The neighbor across the street, Andrea Pierre-Louise, saw a woman she identified as the defendant putting her hand in a window that the defendant, she had seen the woman break the window before, which was the defendant, had seen her put her hand in the window
Some days
immediately.
before, right?
Immediately.
Some days before at the window?
There are numerous breaking of windows, so it's in like the week before, window breaking here, window breaking there. She broke most of the windows on the first floor, which unfortunately created an unlimited source of oxygen for this fire. It's one of the reasons why the fire went up so quickly. In addition to that, the room where the fire started, and that's according to the 3 Commonwealth fire experts, and the people who were in the first floor apartment all put it in that bedroom, which is the bedroom where Andrea Pierre-Louise said she saw the woman put her hand right before the fire, same window where the defendant said she put her hand to light the curtains on fire. That bedroom is the room they were putting all the stuff to be moved. Again, unfortunately, this created unlimited, for lack of a better word, timber that would burn. The curtain burned, the window curtain rod fell into the windowsill, lit to the bureau drawer, which burned, but the rest of the bureau did not. Fire went to the mattress, which was standing straight up, and the mattress was just the combustion of, and they could not put out that fire, and it appears, the people on the first floor said they tried to alert the people upstairs, but it appears they all just ran out and did not call 911 for various reasons. Some had warrants, some just wanted to get out of there. I would like to correct one thing my brother said, where he said the man who investigated the electrical portion of this, that man gave an opinion at it's the transcript of February 19th, page 140 and page 169, where he said it was not electrically based, and that was also the opinion of the 3 Commonwealth experts. So the forensic evidence would support that the defendant did this, and the testimony about this ongoing soap opera, which ends so horribly, tragically, shows the defendant's intent to kill at least Michelle Johnson, but also her statement that she was going to kill everybody there. She was focused her attention on the first floor, but she knew it was a 3-family house. She lived there for a little while. If I could address the defendant's first issue.
Did defense counsel argue in closing that this was maybe second degree but not first degree? Was there any argument that said maybe you should find, I assume the jury was given the option of felony murder?
No. It did not look as though they were.
I don't think this,
This
came back to deliberate premeditation.
There was no jury instruction that said, failing that, you may find the person guilty of felony murder by arson, second degree?
I'm sorry, Your Honor, I don't know the answer to that question, and I apologize for not knowing that. I was focused on the fact that it was a deliberate premeditation verdict return, and so I did not focus on whether there could be a lesser. I did look at the defendant's closing argument, and what the defendant was saying is this was a rush to judgment. They heard on the street this is her. They put all this together. Okay, all those first floor crack addicts say it happened in the bedroom, so all the experts say it happened in the bedroom, so they got to make her say it happened in the bedroom, and they start leaning on her. And he goes, it's all on the voluntariness of this statement. And he used that lawyered up thing. In terms of the being no conversation with defense counsel about the lawyered up term, defense counsel did the motion to suppress. And he's fully familiar with the whole lawyered up issue. So he loses the motion to suppress. He says, Judge, I want to preserve my rights on that. I think you shouldn't let in any of the statements. The judge says I'm relying on Judge Healy's decision. So he says, and this is at transcript February 8th, page 35. He says, at trial, Your Honor, certainly the issue of voluntariness is going to be a live issue. At 35 to 36, he has the explicit request before the jury to play all the recordings. He says at page 36, however, once I assume the court denies that motion and the video to be played, I'm going to ask that all of it be played and that they be played in sequence. But we want it in for the jury to see it. And then in his opening statement, he tells the jury that the defendant wanted a lawyer before she talked to the police and that the jury should watch the video of her interview to see the tactics used on her. That's at February 11th transcript, pages 112 to 113. So obviously he does not object when the video recordings come in, but then says, Judge, may I be heard at sidebar? I just want to make sure my rights are preserved on the motion to suppress.
But was there any request on his part that the judge, which would not be inconsistent, put it all in, but Judge, please give an instruction about there's nothing improper about seeking the advice of counsel, et cetera, et cetera?
He was just asking for the voluntariness instruction, which the judge gave, the
Right, I know
voluntariness
that,
instruction.
yeah, but there's nothing about, don't take an adverse inference out of the fact that she's asking for a lawyer.
I don't recall that statement being made, but if anybody is looking bad on that video, and I don't mean
The
to...
detective.
I don't mean to concede any issue, but from a jury's perspective, if anybody's looking bad on that video, you have two detectives sitting in there, and Detective Persampieri gets up and says, is that thing off about the recording? And the answer from the female detective who's off camera is yes, he thinks the camera's off. And he says, our investigation's going to continue and it's going to get a lot, sometimes
Hotter?
it sounds like hotter or harder. I believe he testified it was harder, but the motion judge found that it was hotter, and I'm afraid that's the result of our Boston accent. But it's going to get a lot
It's really a poor choice of words under the
hotter.
circumstances.
Yeah.
Pretty clever of him at the time.
So, and then she's trying to talk to him, and he's going, oh, no, you lawyered up. You can't talk to me anymore. It's over, and they walk out. And so it's aggressive. He's angry. We have to acknowledge that. And that is what the prosecutor was doing. After she puts in the tapes of the first interview, which is at transcript volume February 22, 113, she puts it in right after 113. You'll see the whole discussion. He knows what's in the tapes. He's preserving his motion to suppress, but he wants the whole thing in for voluntariness. And then when the prosecutor later starts asking the detectives about what's in it and about this lawyered up thing, you'll see that is later on at February 22, pages 120 and 243 to 244.
Can I ask you, just in terms of our review here, Judge Healy conducted an evidentiary hearing,
Yes.
and to what extent does that impinge on our own independent ability to look at the videotape and come to our own conclusions?
Exactly, that you can come to your own conclusions. When you look at the videotape, you review it independently, almost de novo, I guess you would call it, and make your own observations. And I think what you will find is that Judge Healy's extensive and very thorough findings match up to the tape very well. And so I don't think that you will find that your view of the tape is very different from Judge Healy's. So basically the standard of review is Judge Healy makes a decision and you accept that finding of his unless he's clearly erroneous. I suggest to you, when you review that videotape, you will find that he is not clearly erroneous and that you should accept his findings. On the custody issue, that she was not in custody when she made that statement that she wanted a lawyer, that she wasn't in custody until after there's this whole incident where, oh no, you lawyered up, and they walk out on her. And then
But they gave her, even though she wasn't in custody, they gave her Miranda.
Yes.
And that's when she said, I want the lawyer.
Yes.
And that's when they did this backing away business and,
Yes.
and made the comments that they made.
Well-
So there's an open question still about what that means when that happens.
Right. I think, and I suspect that you're talking about Clark, particularly.
Well, actually, we've had in other cases
Yeah.
where it's come up.
I think it's been in Bay. I think it's been in other cases as well, where if the police give Miranda, even though it's in a non-custodial setting, and somebody asserts a Miranda right, are they free to
Ignore that.
to ignore it?
If it's non-custodial, the current state of the law is yes, they are free to ignore it. And if it's custodial,
But they didn't ignore
they're
it
not.
here, so they behaved sort of like you would behave if you were in a custodial setting, got Miranda, exercised the right to silence.
Right, and
Or to
you'll
a lawyer.
you'll see when you view the tape that they're talking over each other, and that when the defendant does say that she wants a lawyer, she does continue talking. But I suggest that Judge Healy's finding that she was not in custody was correct because she believed that she could leave. She had to go take care of her warrant, but she believed that she could leave. The officer says to her, "That's why you're arrested on the warrant." She says, "I wasn't arrested. I didn't come in cuffs." And she did the motion. "I didn't come in cuffs. I came with, Shaft came and got me. I have no problem speaking right now. Everything's coming hard at me." And so then under Santos, the police, because she's still talking while she's saying she wants a lawyer, they're supposed to clarify that then. So Silva says, "Before we proceed any further, I just want you to decide." And she said, "I'd rather have a lawyer," but she keeps talking. "I'm being accused of starting a major fire." And he says, "I didn't bring that up." And then she says, "I'm bringing it up." And he says, "You don't want to talk to us, correct?" And she said, "I don't want to talk unless I got somebody present." And so then Sampieri says, "You want an attorney, yes or no?" And she says, "Yes." And he says, "Conversation is over." And then he does this whole thing. So I would suggest that the motion judge's finding is correct, that at that point, she thinks she leaves. Even when he says conversation is over and gets up, she says, "Am I being held?" She thinks she can leave. And so
But
until
she's
the point that
wrong,
she
isn't
can't,
she's wrong,
the
isn't
fact
she?
that she's
Because
wrong doesn't mean that, custody
she is held
controls.
that night.
But let's presume for a moment that she is held in custody, and Judge Healy, and as I said, he had a very thoughtful and thorough analysis. He said, well, what if it is custody? What if I'm wrong on this? And I would suggest that that does not taint her admission. Her admission occurs on July 7th.
The next day.
The next day. It's the third section of the
Been released in
interviews.
the meantime.
She has, and that is really the big deal here.
She was bailed, right? But she was held overnight.
She was held overnight. She goes to Brockton District Court the next morning to remove her default warrant on the trespass. It's the trespass at the same address. And she's appointed counsel, which I think is
For that.
also very big in terms of the break in the stream of events. And she is released on her own personal recognizance with the Commonwealth's assent. She is not charged with anything to do with the fire. And she is wandering around Brockton until 3 p.m. in the afternoon, where she is found at Veronica Copeland's house. Veronica Copeland is her friend, the one whose car she stole to go over to the fire, and Copeland brought her back, and then she stole the bike from Copeland's house. So it's Copeland's house. The motion judge had that information in front of him, although he did not specifically find it. It's the 26 Market Street address.
That lawyer doesn't play any role in connection with the questioning that's on the 7th, though.
No. And he was appointed on the trespass. But I still think it's significant that she got a lawyer in the interim as well. Not only do you have the release, which is the big thing in the break of stream events, but also that she cleared up that warrant. Now there's nothing hanging over her head, and she did get a lawyer on that. And then the second part of that analysis is the cat out of the bag. As Judge Haley correctly found, as you will see on the videotapes, she did not inculpate herself on the day before. Any information she gave that was favorable to the Commonwealth was stuff that was already known to the police, that she'd had that trespass arrest, that she was in had ill feelings towards the people on the first floor. The police knew that. They arrested her there. There's all these calls coming from that, she's out there again, whatever. A police officer had gone. She had a knife that time. because Tequila Stafford, the third floor resident, she's the aunt of the baby. She and her mother had called the police because the defendant was outside with a knife. The police knew all that information. There was no danger in her admitting that stuff on July 6th. So the cat wasn't out of the bag. She was saying third-party culprit. She was saying Michelle Johnson runs a crack house, and it's her drug dealer she owes money to who set this fire. So then she comes back on July 7th, and now she's in custody. Judge Healy finds she's in custody, and we can see that. And she's given her Miranda, and I want to point that out. She's given her Miranda on July 6th when they have the whole discussion. After she comes back, she gives her Miranda again, waives it. Judge Healy finds voluntarily. Then she spends the night in jail, gets released the next morning. When she comes back on July 3rd, she's given her Miranda again, and then a second time later. So I would suggest, she's had 3 Miranda warnings. She's giving exculpatory statements across the board saying, I had nothing to do with this, I did not do this, I'm not a fire starter, all the way up until getting charged with murder. Once she's charged with murder, she then changes her story to say, okay, I lit the fire, I lit it with a lighter, I lit the curtains, but I'm on drugs, I have mental illness, some people say I'm bipolar, I haven't been taking my medication, they got me all riled up. And I think very significantly is her statement, I didn't think it would get that big, which goes directly to intent and goes directly to intent on defense of deliberate premeditation. So even in her...
How does that help you on deliberate premeditation?
Well, the jury doesn't have to credit that. What I'm saying is the
But why
defendant's
doesn't
putting
that,
her
I mean,
defense
that really
in.
goes to, it can equally go to arson. I mean, the fact of the fire, in fact, it goes the opposite. I didn't think it
would get that big,
Right.
was her statement. She is giving exculpatory statements,
Oh, yeah.
even as she is admitting that she did it, is the point. And self-serving statements on Commonwealth versus Solanskis show voluntariness. So I would suggest that you will find Judge Healy's decision is thoughtful and considered and correct when you review those tapes. And I suggest that the defendant got exactly what she wanted. She got a full hearing on whether Detective Persampieri's statements and even Detective Silva's statements about, defendant doesn't bring it up, but I wanted to make note of it, the now or never theme that you see in Commonwealth versus Novo. He says to her, if you don't tell us now, jury won't hear it. And she says, why won't they? And he goes, oh, no, the jury can hear it if you tell them, but they won't believe you because you won't have said it now. And that is actually an accurate statement of the law. It's not misleading. It's not false. It's accurately telling the defendant, like, you're talking now. If you don't tell the whole story, the jury may not believe it in the future. And so that now or never theme that you see in Novo is not really applicable here. So I would ask this court to affirm the defendant's convictions in this very serious fire that took a young mother's life and left that child motherless. And they had nothing to do with those first floor tenants. They were just innocent collateral damage. I would ask this court to affirm those convictions, and I would ask you to affirm Judge Healy's order and find that trial counsel's actions from his opening statement to his closing argument, even his expert on the voluntariness of statements, all show that this was a well-thought-out, planned strategy. He was not ineffective. This was the best strategy he had in those circumstances.
Thank you, counsel.
Thank you.
Mr. Smith.
Thank you, Your Honor. Just very narrowly on the point that my sister had raised, she said essentially if anything, these detectives look bad. Well, again, it sort of just begs the question. I would suggest, if anything, the jury repeatedly hearing, that Ms. Thomas had invoked her right to counsel, that's what looked bad. The case law recognizes this. Doyle, Pelexto, of course, recognized the principle that the jury should not hear that. So the question I would suggest comes down to, was it a reasonable strategy? And again, my sister respectfully did not address that issue, which is, in this case, on these facts, there was ample evidence upon which to mount an attack as to the voluntariness of her statements. And it's her state of mind. It's the presence of multiple officers. It's the repeated, these 2 or 3 detectives repeatedly coming back at her. The idea of the statement lawyered up, that somehow that was necessary to.
So as if, you just, I'm having a little trouble here, because isn't part of, I mean, isn't the voluntariness business all sort of, I mean, Justice Spotsford raised this before, sort of circling around whether or not, once she asked for a lawyer, they came at her and made her feel guilty, made her feel, so the jury would have to know that she asked for a lawyer, right?
No.
In order to understand how it was that the police were taking the position that they were taking. So are you saying that there's some other part of the videotape entirely that goes to voluntariness?
The entire videotape.
The entire
to her
videotape.
state of mind. It goes to what the police did. I mean, my point is, Your Honor, there was plenty of evidence
Give me
here
something else.
without that right to counsel.
Let's talk about another part of the videotape that had nothing to do with lawyering, that was somehow went to voluntariness.
Well, it's her demeanor, Your Honor. It's
Her
the fact-
demeanor.
It's her demeanor. It's combined with the fact that her friend had said she was on a crack cocaine bender for days,
Yes.
hadn't slept, was high. So all of those things go to whether or not these statements were voluntarily made.
So you would basically say there was enough there just in terms of whether she was somehow intoxicated.
Correct.
While
And-
during the 2 days of the, and that alone, you wouldn't need to ever touch on the lawyer point or their reaction to that.
All of those things made it such that the lawyering up, the invocation of the right to counsel never should have been heard. I mean, I would suggest that all it would have taken would be for the defense counsel to have asked. I mean, Your Honor, we lost the motion to suppress. It is what it is at this point. He properly preserved her rights if assuming that was necessary. And then he could have just said, but as to her invocation, Your Honor, it was repeated. It was not only repeated, it was used with this phrase lawyered up, and that easily could have been, Your Honor, simply excised from those tapes. I mean,
Mr. Smith, your time is up.
thank you very much.